Usted no tiene this back, that's for you. Okay. Voy a llenar entonces los papeles. And I'll be right back with the top. Okay. Theodora Antar.
Hi. So is there somebody that's a domestic violence advocate that's able to speak to me?
Not that I can give you right now in this building, no.
And this is
Not that
one
I'm
for you
aware
to
of.
mail.
They're a victims
and one
advocate
for
in the
you.
criminal court across the street from the office of victims advocate, but they normally are
one
not
of these
victims
you're gonna
advocate,
mail
as I already
to
told you, in family
this
court.
person.
If you want to
To Jorge.
request any accommodations, you have to make this up.
Okay, but you're
I've
saying
got-
100% there's no, only for the criminal court, there's none here, you're like confirmed
I
that?
hope you are not recording this.
No, I'm just saying, I just want to confirm that.
To the best of my knowledge, I'm telling you what my knowledge is. If I'm wrong, then I'm wrong, but to the best of my knowledge, I've never seen a victim's advocate in family, and I will stress family restraining order here.
Okay, is there somebody that's like a supervisor that I could confirm that with?
Happy to get someone else.
Okay, thanks.
Okay.
Can I help with next? Can you put the name and address of your employer? Mike.
Not for 150 years. Is that measurable? 109. Okay.
Hello.
Le mando los papeles a él, el papel que le tengo que mandar, y espero a su esposo. Sí, sí. Y espero que ustedes se dejen conmigo.
Bueno, usted solo tiene que dar el divorcio.
No, un papel que ella me dio, que me dijo que se lo mandara por correo.
Oh, sí.
Y entonces mando ese papel por correo y espero que se comunique conmigo.
Entonces, ¿qué cosa de papelera? Déjame ver. ¿Ese papel usted?
Sí.
Oh, que
For
sí.
myself?
Usted lo
Okay.
that would be right.
Yes.
Oh, bien.
Okay.
Sí.
Cuando reciba el correo, tengo que volver aquí. Ok.
Okay, if you and me
Okay.
the 23rd today.
I started it and didn't even.
Thank you.
You're welcome. And I'm all set? Okay. Thank you.
It would be 0 for others.
You ready?
So that fee waiver, I have to give you a different
Oh,
one.
give me the different one.
Pardon me?
Give me the different one and I'll fill it out.
Okay. So it's transcript for criminal
Yeah,
case,
it's
correct?
gonna get attached to this.
All right, I'll be right back.
Yep.
what day family court falls on? Is it a Thursday or Friday?
We do stuff every day, or looking specifically for.
No, I just wanted to know. I prefer Thursdays.
It's kind of like, they just want to schedule.
Yeah.
Yeah, they hear on Monday to Friday, so.
Okay.
It's hard to guarantee anything.
Okay. Thank you.
We're looking for you
You too.
upstairs in Judge Griffin's courtroom.
Okay, she said she was getting a supervisor.
Oh, I don't know, I just got the call downstairs that they were seeing if you were in the clerk's office.
Okay, was Gina able to get that supervisor? She told me
I'm
to.
sorry, I didn't know. What did you need it for?
I was saying because like it was saying that like according to the state law, you guys are supposed to have like domestic violence advocates for this type of restraining orders, like they do in Milford for not just the criminal cases but for the family cases by law. And she's telling me that New Haven doesn't do that. I filed this case in Milford for a reason, and they forced it to be transferred here. Now I'm being told I can't have an ADA accommodation looked at. I can't have this advocate with me when that's what the law says, and Milford does that, no problem. They say, yep, come to the clerk's office, fill this out before the hearing. Why is New Haven not doing the same? Okay, well, I don't want my rights to be denied just because I'm being forced to come here when this is outside my JD.
Here, I'm ready.
I have a question. Is anybody here in Josh, my thing?
Yeah, I've seen that stamp before.
Okay, perfect, thanks.
She's coming.
Oh. Okay, that's the right one.
That is,
Yeah.
absolutely is. Okay. So I don't even need this one.
But maybe you'll find information on that one that you can transfer.
Shouldn't take me too long.
If you wouldn't mind taking this info.
Yeah. You mind if I share this table with you?
No.
No, you're good. You don't have to move. Both of these courthouses in New Haven don't have their shit together, so don't worry. We tried to tell you you can't have a victim's advocate. Yeah, they're a fucking joke.
The deputy chief clerk will be out in a few minutes.
Okay, and I'm sorry, like aren't we supposed to meet with family relations? Because I would like to have that opportunity to meet with family relations.
I don't know, this is just the clerk's office part, that's done upstairs.
Okay, but you're saying that we're not meeting with family relations. We're expected. You're telling me they're in the courtroom and we're not
I
getting.
said we don't do that down here.
I know, but you told me that Judge Griffin's courtroom was waiting for me to go in there, correct?
They said that you're on for Judge Griffin's courtroom, they're calling cases, and they asked if they saw anybody down here.
Why aren't we going to family relations first? I'd like to speak to family relations.
I don't know.
I know, but I have the right to talk to family relations. For you guys to just send us straight to the courtroom without it is again violating my.
Took a phone call and asked if you were here.
Okay, I'm sorry. What was your name?
Mike.
Mike. Okay.
And then everything, yeah, 7 to 10 days. Yeah.
I don't gotta do nothing yet, right? I gotta do something else.
Just gonna have you, word to it.
Okay.
Okay, she said to give her this, and I wanted to know if this can be looked at right now, like they do in Milford. Before I go there, I'd ask to speak to family relations prior to getting thrown into the hearing like that. I haven't been able to meet with, I have been denied the opportunity to meet with family relations in every court proceeding, and it's been probably 1 year since I've met with family relations. And so I think that I'd like to have an opportunity to do that, not be forced to go in when everybody else usually goes. Okay. Hi.
You ready real quick?
I did, and I'm asking why we're not getting the opportunity to meet with family relations like every other person does. Typically, you meet with family relations prior to going in front of the judge, and I wanted to know why we're not doing.
I raised my
We did,
hand.
and I've been on the phone with you
understand.
guys for 40 minutes before I came in here now trying to
Yeah.
ask for this. And Milford always allows for me to go in, speak to the clerk, speak to the ADA contact. They have victim advocates on staff. I specifically filed this in Milford. I don't live in New Haven. New Haven is not my JD. None of us live in New Haven or have this JD. I filed this in Milford, you guys transferred it here. I said I want the same protections for my ADA rights, for my rights under domestic violence laws as I get in Milford.
Yeah, I didn't understand a word you said, but
I'm sorry, I can't hear you.
I said I couldn't hear a word you said, but I know what you're saying. Don't worry.
No, I wanted to speak to family relations. Why am I not being allowed to talk to family
How many
relations?
times have I done
I'm
this
sorry, I
with
can't
guys
hear
right
you.
now? I wish that I didn't even have to do fee waivers for now, that you guys just know that I'm freaking broke as shit until I come tell you guys, hey, I'm not broke as shit no more.
And when will this be looked at? Because like
It's
I don't
not-
want to just get thrown in front of the judge again. I'd like
no,
to speak
no,
to family
I'm being
relations.
funny,
I'd like to
trust
speak
me.
to an
I
advocate.
wasn't- I think it's hilarious. Like, you gotta understand the way.
What do you mean it's up to me to do what I want? Is this going to get looked at now or before the
I
hearing?
have good friends. I got shitty family.
I'm sorry, I can't hear you. You're speaking so quiet.
Your case is stuck for 90 days, and end up missing it. But I'm
So you're telling me that this will not get looked at, I will not get to talk to family relations or an advocate or get an answer, and you're going to tell me I'm missing my case?
Yeah, you're good.
So then what is happening with this?
We're gonna send it up
Send it up to who?
to the ADA office, and
I thought that Gina was the coordinator for that.
it's gonna go up to ADA.
Okay, and is there an advocate I could speak to or no? Excuse me.
I'll bring this, to the criminal clerk. You should get this back.
Yeah, I'll get it snapped and then drop it off over here again for you guys to get
That's
to the
correct.
clerk.
You'll go to the
Yeah.
7th floor when you get it back.
When I'm just trying to remember. So I'm gonna get the fee waiver back with the thing. I gotta bring it to you guys to file it, or I gotta just bring the
Seventh
transcript
floor.
to them directly. Okay.
That is correct.
Awesome.
Alrighty. Take
Thanks.
care.
You too.
Thank you.
She's not here. No, Denise. She said today came this. But I don't know what she did.
And she just, the same day she's telling her dad to let her go to the house. So how do you get this to a place where Lily's not getting crazy every single day?
I asked the clerk's office, I filled out the form, and they said, go up here. Is there somebody from family relations? I just put my name on the sheet. I'm not sure. Which court do I have to go to?
What's your name?
Last name is Antar, A-N-T-A-R. and it was under last name Lodice, Lodice. So just go in there and check in?
Yeah. Yeah.
Okay. Opportunity to meet with family relations prior to going in front of the judge, and they said to me that I have to just go upstairs. And so I, again, like last time I was here, I was not given the opportunity to meet with family relations or have my accommodation looked at. And every time when I go to court in Milford, they do allow that. And I filed this case in Milford because New Haven's not doing those things, and I asked for a victim advocate to be present. I was told that New Haven doesn't offer that, even though every court is supposed to have one. So is there somebody I could speak to in family relations prior to this starting, or somebody that can address the accommodation I just gave the clerk's office?
Let me go find out.
Should I just wait outside the courtroom? Or?
Inside or outside?
Because I don't want to be in the same room as him. He continuously keeps threatening to have me arrested. There's multiple protective orders. I don't want to be near him.
Then
Can I
you
wait
go out
outside,
in the
please?
hallway. Just stay close to the door.
I'll be right outside. Thank you.
Sense? Peter drew the day of, or he told me to go something to the next day was I mean, I'm about to call him today because I wasn't told him to start today or just to start his day. I'm not sure if he's going to do it, so I'm going around for Robson and that's why I called it. So yeah, I'm gonna have him do it tomorrow. And then say it's your fault. It was me. Life, you gotta. Oh, I see. That's why I called it. Good luck. Say less. Say less. I got food. This and then we'll do it to the clerk. Yeah. I'll make copies. Do it to the clerk.
I'm sure they'll put it on the file, right? So
correct.
you can just draw it in there. I don't make copies.
You're not trying to cash me out.
I'll send you guys an email.
All right, awesome. Thank you.
Status of 30 days.
Yeah. Yeah, sounds good. Thanks.
Ma'am, Judge just called please.
Okay, so am I going to get a chance to speak to somebody regarding what I just asked the clerk, or am I going to have to go right in front of the judge again like last time?
Well, the judge is waiting for you to call for you, so.
Okay, so the clerk told me to wait out here. I said I didn't want to be near him. There's 2 protective orders. I don't feel...
The judge is on the bench right now waiting for you to come in.
Okay, so am I being given an ultimatum that I either go directly into the hearing?
Ma'am,
I made a
the judge
request.
is on the bench, so you have to ask that of the judge.
And
The
you
clerk doesn't have
you
anything,
get
so.
no insult.
Do you not want to come in, ma'am?
I'd like to know what to do about the
It's
request.
either yes or no.
Yes or no what?
Do you want to come in? The judge wants to know.
I'm going to have to go near the same person that with, even though with the protective order, even though I requested this accommodation, I won't get to talk to family relations?
Do you want to come in?
Do I want to come in what? Am I,
To talk to the judge?
is that my option?
Punish us, and then the other thing is what you do, you already
Are you proceeding with the case, ma'am?
I was asking for a reasonable accommodation due to the ADA, and I submitted that downstairs. I also requested to not have to be next to him due to protective orders in effect, and I asked to speak to family relations, and the clerk said to wait outside. Is that something that can be acted upon prior to this starting? Milford usually does that, and I filed this case in Milford. My rights don't get violated with this in Milford, and I want to know why I'm not being allowed to speak to family relations, why I can't get an answer about the ADA accommodation, and why nobody's giving an answer about that prior to this starting.
What time did you arrive?
I was sitting outside here on the phone with New Haven Superior Court for about 40 minutes trying to get in touch with the ADA person.
That was not my question. My question was, what time did you arrive here?
I arrived here at 9:30 and I was on the phone with the person from the ADA.
Did you check in with the clerk at 9:30?
I checked in speaking to the clerk's office.
Okay. Did you check in with the clerk?
Not with this clerk.
Okay. Have you checked in with the clerk at all this morning?
Yes, I did, and I explained to her what I just said to you, and she asked me to wait outside.
When did you do that?
Just about 10 minutes ago.
The case was on for 9:30. So
I understand.
You were expected to be here in the courtroom at 9:30. The case is about to be dismissed. So all these things that you're bringing up that you're trying to deal with now after your case got called could have been dealt with over the last 2 weeks. If you chose to wait till it's too late, that's your fault. That's on the clerk's step. So do you intend to proceed with the case today or not? That's my question to you. That's a yes or no answer.
Yes, will I get a chance to have my ADA accommodation addressed prior to the hearing? Yes or no? Will I get my ADA accommodation ruled on?
When did you file it?
Today.
After 9:30?
I'm asking for this to be a reasonable accommodation. I'm a pro se litigant. I have disabilities. I'm doing the best I can. I also asked for an advocate. By state law, the domestic violence law says there should be an advocate present. They told me there are none in this courtroom.
This is not your first time doing this, so you're familiar.
What is this is not my first time doing this mean?
This is you're familiar with the court procedure.
What does that mean? I'm familiar with the court procedures. I'm a pro se litigant. I'm not an attorney. I'm not familiar. My rights are being violated. I'm asking to speak to family relations. Why am I being denied that?
Because you're too combative with family relations and you have been in the past.
I'm too combative in what way? I haven't seen them in a year.
I'm not sending the case to family relations. So my question to you again is if you would proceed with your case, you could sit down, you could put your things down, you could put your restraining order case on, or else I'm going to dismiss it. What's your pleasure?
Okay, so am I being given an ultimatum to proceed without my accommodation being addressed?
We will get to that if you intend on proceeding with it. I haven't even found out whether you intend to proceed with your restraining order.
I said yes.
Okay, good. Then have a seat.
Okay, I just would like to have that accommodation looked at, please, because it's very simple and I'm not asking for much. It's very reasonable.
So, we have 9 restraining order cases in the docket today. They're all filed on behalf of the Angelo Lodice, the minor child. Filed by Mr. Antar against Mr. Lodice. According to what I can see in the docket, there's only been service filed on docket ending 1850. The remaining 8 restraining orders do not have return to service filed. Did you have those served on Mr. Lodice, ma'am?
I gave them all to Attorney Marshal Robert Miller, and I forwarded all of the ones that were sent to me via email to Marietta.
Do you have a return of service for the other 8 matters? Because there's only a return of service filed on docket ending 8250.
Okay, I'm sorry. Hold on one second, please.
Where were you served on that one?
The only one I have is the one ending in 8250.
Did you get served on any other? Do you think or do you have return of service for those matters or not?
I'm sorry, just give me 1 second. I'm just trying to get this out. Tell me again, which one you said you did get a return of service?
Ending 8250.
Do you have the full docket, please?
I do. It's NNH FA 23-505-8250. Mr. Lodice indicates he was served in that case. I have return of service from the docket in that case. I do not have
Yes, I gave all of them to the same marshal, which is Robert Miller. I sent this via email because all of these were given to me.
Did he provide to you a return of service because he did not file it with the clerk's office?
They did not reach out to me afterwards. They said they would serve it and take care of it, so I have not contacted.
You don't have a return of service for those?
No.
Okay, so in that case, those cases are dismissed for lack of service.
Okay, can you just tell me which ones those are, please, so I can just document it?
It's everything except docket ending 8250.
Can you provide those to me? Because I didn't even know that there was 9 dockets. Can you just, for clarification, tell me which one?
You filed it. You can get a copy of the court's docket. I'm not going to take up court time.
How can I know which dockets to get a copy if you won't provide the docket numbers?
You can take a look at the court's docket and you can look at the other 8 cases on there that are not ending in 8250, and then you will know the docket numbers. I'm not doing that research for you.
Is that something I can access today, or?
You can talk to the court's docket about that. We're going to proceed on docket ending 8250. And both parties, please stand and face the court.
Just raise your right hand, ma'am. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you're about to give concerning this case shall be the truth, the whole truth, and nothing but the truth, so be about or comparable to perjury? So please say I do.
Do.
I do. You put your hand down, starting with you, sir, just state your full name and address for the court record.
Matthew Lodice, 48 Court Hill Road, Waterbury, Connecticut, 06706.
Thank you, and you, ma'am.
Theodora Antar, 856 Shardbark Drive, Orange, Connecticut, 06477.
You can take a seat. Ma'am, what accommodations are you looking for today?
For privacy purposes, I'd like it to just be what I wrote down on the form.
In terms of what you present?
I'm sorry?
What do you mean by that? I want to make sure I understand.
The clerk's office, I gave the clerk's office a written request. Is that something that you're able to look at?
I don't have that. Would you have something you wish to hand in? But if you file it with me, it is something that the public could access.
Well, I was
To the
told,
clerk's office.
I was
If you
told
wish
by,
to- If you wish to hand it to me in writing, you can do that.
is it something that they can arrange the clerk's office to bring upstairs since I gave it to them?
I see the difficulty is that you did all this after the time this hearing was supposed to start. So now I'm delaying hearing other people's cases to accommodate these things when these things have been handled in advance. Do you have a copy of this ADA form that was filed? Do you have a copy to hand me?
Well, I just did it by hand. I took a photo of it. I can, if there's a way to print something right now, or I could go down to the clerk's office and ask them to give a copy. I just gave it to them. I didn't type it. Is that something that can be done? I was expecting to also speak to an advocate. Is that something that can be accomplished?
All of that needs to be arranged before the start of the hearing. And this hearing has been noticed since you filed the application. All of that needs to be arranged.
So you
This
guys-
is the 9:30 times to check in, and the court is ready to begin the hearing.
Okay, but,
If you have not reached out to the Family Violence Victim Advocate Office, or you have an issue with them, that's something you have to take up with them.
okay, because the
If
clerk's
you're
office said there is
informed,
no
yes.
office. The clerk said there's no such office in this court, so I'm just confused
They
because,
have an office over in the GA.
so is that only for criminal matters, like they said?
I have no idea, they don't work for me.
Okay, so how would I have reached out to them if they don't exist in this court? And this isn't a criminal case? There's no way for me to reach out to, New Haven doesn't have that.
Yeah.
Milford does, these were filed in Milford, so if I was in Milford, I would have an opportunity to have a DV advocate next to
Did you
me.
reach out to Milford to see if they had a contact with the office in New Haven?
They said I had to speak to New Haven, and New Haven says that they don't follow that law or comply with that law. So I just want to know why I'm being denied that opportunity and also being forced to come to New Haven when neither me or the respondent reside within this JD.
Your case was transferred here, that's why you're here.
So my case was transferred here, but this court also will not comply with the state law to provide advocates with restraining order applicants.
Well, my question to you before, I think I know the answer to it, was did you contact the family violence victim advocate's office, which is they reside over in the building? Whether they come here, I'm sure they do. We have domestic violence cases here, we have criminal courts here as well. But did you contact them?
I did not contact the criminal court, no.
Well, not the criminal court, the family violence victim advocate's office.
Is that the one in the criminal court on 121 Elm Street?
That is.
No, I did not think to contact the criminal court DV advocate office.
Well, it's the New Haven family violence victim advocate office. They're not necessarily attached just to New Haven.
Well, I was not given any of this information. I have no way to know this information off the top of my head.
The time to ask about it would have been before your hearing started.
Okay. So the court doesn't make reasonable accommodations for those with disabilities and those who don't have attorneys? The law is supposed to also provide attorneys for those, for restraining order applicants, but New Haven Legal Aid doesn't allow that.
The law allows the court to be solicitous to pro se litigants, but does not allow me to bend the rules.
What about the ADA? Under federal law, the Americans with Disabilities Act is a requirement. It's not an option.
And you would need to timely alert the court to your needs so that the court can react without substantially interfering with the court's business. Now, I am getting your ADA request is coming through now, so give me a moment to take a look at this. The only accommodation I can offer you is that if you wish, you can do this for a remote proceeding, and I can put you in a room where you can hear remotely. You also could have requested that directly to the court in advance, and the court could have set that up in advance. But no request was made to copy.
Okay, and if I want to do that, is that something I can right now go do? I'd like to do that, please.
I would set that up immediately.
Okay.
Because we need the procedure for you.
Okay.
May I ask a question?
Yes, sir.
Will I have to be sitting in the room? that if they're agreeing to present evidence, because now that it's turning to the law, we're not actually able to upload it.
Cross that bridge.
Does this matter being passed now?
It'll be passed. Thank you for your patience. Marshall, I think we have some available.
Okay, so I'll wait here. Thank you. Are you going to be sitting here for a minute?
Yeah.
I just want to get some water. Is it okay? Can you just watch myself for 1 second? Thank you so much. He was saying like the docket, like asked like what cases were on, and he said like it's on the docket. Is that something that's posted on the wall?
Yeah, but you can't take a picture, you can just write it down.
Okay, is it even a restraining order ones get put on the wall?
No.
And that? Okay.
Thursday afternoon. But Thursday. They refused to come to Thursday afternoon.
3E, all the way down north.
Ma'am, the gentleman that was keeping an eye on your items, he went into the courtroom, okay?
Okay, thank you.
No problem.
Yeah, because they're just trying to figure it out now. The case flow coordinator's trying to figure out what rooms
Okay.
can be used. So I just wanted to let you know, so I'm gonna just mark you off on the sign-up sheet, okay?
Okay, I'm
And
just gonna sit here and let my laptop.
Okay, no problem.
Thank you.
Perfect. Last name Page? Page, okay. Is he ever hurry? Oh, my coworker was calling you. Okay, yeah, he was calling you a couple of minutes ago. What's your full last name, sir? Hi, good morning. I have called earlier about just saying I can have a report emailed to me. I just wanted to check in and see if those emails is to modify our training order. Okay, come on. You talk to her first, okay? I sent it. I sent, yeah, that's the. Okay. Just sent the email. Yeah, I understand. Anything? Even on the records at Camden? It's records at Camden. PD. Records with an S, right? With an S, yes. Sending it again. Oh, thank you. It's Miss M.S. Gonzalez, Gonzalez, 8210 @gmail.com. Yes.
Yeah.
Alright, so we have you set up in 426. Okay. Do you want me to show you how everyone? Okay.
And then mail have 628.
Okay. Because like you can't e-file on these kind of cases unless you're given permission, and then you request permission at the courthouse. So like there's all these barriers, and it's just like not fair when you're not, even as a pro se, they don't let you e-file when like lawyers can, and then
They don't even let me in here, so.
Is there a water fountain up there too? Okay, I'm assuming this.
Yeah. So that's what it's gonna look like. Then again, once I invite you, everything is live, okay?
Okay.
And we'll shut from the outside.
And am I able to like just get set up like through?
Yeah, take your time.
Okay.
We're still on a proceeding, downstairs.
Okay.
Take your time. It should be on in about 5 or 10 minutes.
Okay, and then
Alright?
so it'll just pop on?
It'll just pop on, all right?
Okay, thank you.
Hi, this is the clerk. Can everyone hear me okay?
Yes.
Yes.
All right, thank you. We can go on the record.
One moment, Madam Clerk. We're on the record now, Your Honor.
Good morning. This is a continuation of our hearing in docket ending 8250 in the matter of Lodice versus Lodice. This is a restraining order application. At the request of the applicant, or I should say the representative of the applicant, matter was converted to a remote proceeding, and we will continue with our hearing now. Both parties have been sworn. Ms. Antar, did you want to take anything up before the court hears evidence from you?
Did I want to what? I'm sorry?
Do you want to take anything else up or put anything else on the record before we begin with evidence?
I just wanted to know how if we have evidence we'd like to do, whether it's paper or electronic, how we will do it during this remote proceeding.
Okay, if there's a paper exhibit that the court is going to be accepting, I can have my clerk come up and grab a copy of it from you because both of you are still in the courthouse. And I will note for the record that there's a remote proceeding, you're both still in the courthouse, but you're in separate rooms, in separate locations within the courthouse. And there is a marshal who's stationed outside of the remote room where you are, Ms. Antar. So I will have the clerk, if I need to obtain any paperwork from the two of you, from either of you, the clerk can go up there and retrieve those documents. Now, in terms of anything electronic, what are you intending to offer that's electronic?
Well, there is a video that I, if needed, would like to play. So I didn't know.
Okay, what kind of media do you have that on? Is it on like a thumb drive? Is it on a phone or?
It's on the phone and laptop, and I can put it on a blank thumb drive that I have here.
Okay, I would need it on some sort of thumb drive or the like in order to receive it, because if I receive any kind of evidence in that form, a video or audio recording and it's digital, I have to keep a copy of it for the record. And I would prefer not to keep your computer or your phone.
Okay, is that something that I can provide to the court now? Because I do have a flash drive and I can put it on there right now.
Well, why don't we commence with the hearing, and then let's see if we get there and if we need it.
Okay.
Is there anything else you'd like to address with the court before we begin evidence?
I just want to know how will this proceeding go? Will I have a chance to testify and speak? How will this?
So the ordinary course of this is that this is an application that you filed on behalf of the minor child. You're here as a representative, so you will proceed with your evidence. You'll have the opportunity to present your case. And then at the conclusion of that, if the court wishes to hear, or if Mr. Lodice has information he wishes to present, then he'll have an opportunity to testify or present evidence. And if at any point in time you wish to ask Mr. Lodice questions, you can let me know and we can arrange for that as well.
Thank you.
Okay, and will I be given the opportunity to cross-examine him?
If he testifies, yes. But if you have questions for him in advance of that, you will need to let me know that.
Okay.
Does that make sense? So if you wish to present questions or answers from him as part of your case, you need to let me know so that I can provide that opportunity, because he does not have to testify. So if he chooses not to, then you will not have an opportunity to cross-examine. Does that make sense?
Yes, and I would like to ask him questions.
Okay. So is there anything else to take up before we proceed with evidence?
No.
All right. Mr. Lodice, do you have anything to take up before we proceed with evidence?
No, Your Honor.
All right. Ms. Antar, this is your case. Go right ahead. What would you like to tell the court?
Okay.
Now, I should start by saying I have read your application, and I have read the affidavit in support. Do you swear that the information in there is true and correct to the best of your knowledge?
Yes.
Okay. Is there anything else that you'd like to add or tell the court in connection with your application?
Yes, when this application was filed, I indicated here that Mr. Lodice was charged with 53A-167A for interfering with an officer and resisting arrest. However, after that, I also was informed that he was also charged with felony risk of injury to a minor in connection with this incident. And I would like to present the recording of this phone call, which was the subject of the incident, which then resulted in his arrest.
Objection, Your Honor. Your Honor, under penal code, or what is it, general statutes, I believe it's 52-57, it's illegal to record phone calls without both parties consenting, and I nor my daughter ever consented to being recorded during a phone call.
Ms. Antar, did you have permission to record the phone call?
There's no such statute that says that it's illegal to record in this state, and if there was, I would like him to provide evidence of such.
Well, that wasn't my question. Hold on. My question was, did you have permission to record the phone call?
I was instructed by Officer Fernandez of the Orange Police Department to record any and all communications with Mr. Lodice for my protection, and in Connecticut, it's a one-party state, so by law, I have every right to do it as long as only one party consents, which is myself.
So again, I'll ask one more time. Did you have consent from anyone on the phone call to record the phone conversation?
Yes, I have documentation in our family wizard of Mr. Lodice stating that I can record and that it's fine to record.
Okay. Mr. Lodice, did you give her that permission?
I have not. I've said multiple times in our app that that I do not feel comfortable with her recording a phone call. I do not want to do it, and I've also said it on the phone while I see her visibly recording.
That right, Ms. Antar?
That's actually incorrect, and I could actually provide documentation and evidence from our family wizard of him and phone calls in which he says it's fine to record. Also wanted to note that these calls are not, he's not involved in these calls. These are calls between myself and my minor daughter.
Your Honor, I have full custody of said minor daughter, therefore I have the decision whether she can record these calls or not.
Also, I'd
so
like
this
to...
phone call that
Yes.
This phone call that you're intending to offer, is that a call between you and the minor child?
It's a call between myself, my 9-year-old daughter, who I have sole custody of, and my minor daughter, Angelina, who is the applicant in this. And I also like to say that the police, as well as DCF, have also been given this full video, which is 29 minutes long, and I was hoping to play just one portion of it. And also it's the fact that Mr. Lodice on numerous occasions has said and mocked and taunted me and said, go ahead, you can record all you want. It's not admissible in court. I'll just object. And then he just is abusive during phone calls, and then he claims that he'll just object and say that he's not going to allow it in evidence, and then continue to abuse and say that the evidence won't be admissible. And that's what his strategy is. And so I'm asking that not be stopping us from proving the abuse.
Your Honor, it's also been court ordered that she's not allowed to record a conversation between her and my daughter.
Objection, that's false, and he's lying under oath.
Not, it has been ordered.
What order are you
Objection.
referencing, sir?
It's from one of our...
His objection first.
It's from one of our court orders from about, I can't even tell you the exact day. We've been there so many times that I don't know. I want to say it's maybe the April 8th one from last year.
Objection, that's incorrect.
From 2022.
Do you know when it was, ma'am?
I'm objecting to that. He's lying under oath. There was no order in April of 2022 saying I can't record, and I was instructed by the police department to do so for my protection. And also there's a law in Connecticut, for the record, that states that if somebody is committing a crime such as harassment, that you have every right to record, and none of that stuff goes into effect. And so because he is consistently harassing me, which is a criminal crime in the state of Connecticut, I have every right to do that in order to protect myself and my minor daughter. He is extremely dangerous. He was arrested, and the police had to kick the door down because he refused to give my child medical attention after she screamed in pain, saying that her butt hurt and her stomach hurt. He is completely isolated me from my child, and under Connecticut state law, that's considered domestic violence, isolating somebody from their family member. Angelina has been completely isolated from me. She's been isolated from any and all support systems. She has not been allowed to attend church, school, therapy. She has not been allowed to do any of the above. He said to me he will not let me contact her at all or see her at all. I have not spoken to my child in 15 days straight. I have not seen my child in 2 consecutive months. In the last 5 months, from May 25th until present, I've seen my child for the equivalent of less than 2 days total. If anybody listening to this on the record thinks that that is in the best interest of my 4-year-old minor daughter to have no contact and no visitation or access with me whatsoever, and does not recognize this as coercion, coercive control, psychological abuse, and isolating one from their family member and support system, then I'm questioning the integrity of the judicial system as a whole. Because this is abuse. I have no reason not to see my daughter. I've never been proven unfit. He has no justification to keep her away from me. And he stated to me in the app, after he was arrested with felony risk of injury to a minor charge, that as a result, in retaliation, he is now never going to let me see or speak to her again. And since he has blocked me and he has threatened to have me arrested if I try to contact my daughter again. This is abuse. I want this on the record. This is abuse.
Let me go back to where we started with your recording. I'm looking at an order that was issued by the court on June 28th of 2022. It was issued by Judge Grossman in this court in a custody matter regarding a minor child who is subject of this restraining order application. That docket number is NNH FA 195046828. The order there at 184 on the docket indicates orders that neither party is permitted to record the child's phone calls.
So for the record, is that temporary order that you're referring to still in effect? Because if it is, then Mr. Lodice is in violation by not bringing the child to Sunday school. Is that order still in effect? It was a temporary order that was replaced with a final order on May 31st, 2023. Those temporary orders are no longer in effect. And if they are, Mr. Lodice is in contempt of court by refusing to bring the child to church. So my understanding is that temporary order is no longer in effect since it was replaced with a final order. So you're saying it is in effect?
I can't even finish my sentence before you start speaking.
Go ahead. I'm sorry.
That order would remain in effect unless superseded by a subsequent court order, because these are post-judgment orders, because the case went to judgment originally back in 2019. So ordinarily, yes, a final judgment would displace temporary orders, but the case already has final orders and then has had a number of other orders issued subsequently.
Okay, so
I will also note regarding your claims about the visitation and the like, and the final orders and what's still in place, is that there was a subsequent order issued by the court, Judge Grossman, that appears at 266 in the docket that was issued May 31st, that gives the father sole legal and physical custody of the minor child, that the access with the mother is determined by the father and may only be in the presence of a third party designated by the father.
Okay, so just...
Go ahead.
I'm sorry, just because, again, I'm not an attorney. I'm extremely confused about what is and is not in effect because of this. And my understanding is that we had a very detailed final judgment order, which was both signed by both of us. The last time that we signed an agreement was in April of 2022. Judge Price Borland on April 12th of 2022 said that she felt that that order was in the best interest of our daughter and entered it as a final order. Then Judge Grossman entered in a temporary order in June of 2022. And then again, additional temporary order was entered by you in 2023 after an ex parte. And then that temporary order was entered after a hearing as well. After that, we had a order that was again temporary on May 25th, and then a final order on May 31st without court appearance, and another final order on June 22nd after a court appearance on June 15th. And so, to my understanding, I was told by Mr. Lodice that any and all orders that were entered in prior to May 31st are no longer in effect and are completely void. And he has said that he has the legal authority, and he now has all of the authority and absolute power to completely stop me from having any contact or access with my child. And he has stated that he has gotten confirmation from this directly from the court. And so my question is,
I just read the orders that apply to that, and those orders would supersede any inconsistent orders. That order also indicates expressly the father is no longer obligated to bring the child to a church or religious events at the mother's church on his parenting time. So those are the current orders that are in effect. And if there are any prior final orders or any prior post-judgment orders that have been issued that are inconsistent with those orders, they would be superseded by the subsequent orders. So now I'd like to go back to your allegations. We'll put the video aside for a moment and we'll address that shortly, because just because one party didn't consent to the recording does not automatically make it inadmissible for the purposes of evidence, up to the court whether I will admit it. But Ms. Antar, I'd like to hear from you before we get to presenting evidence. I think I got a flavor of it when you were answering some of my questions about the phone call, but why are you requesting a restraining order here on behalf of the minor child?
Just to follow up on what you said before I get into that, may I just ask one more question?
Sure.
So I just want to make sure I'm clear about, what are you saying, that any orders that were in effect prior to the 31st or any agreements that we signed and contracts we signed are completely void, or are any of those still prior orders in effect? Because I was under the understanding they're not.
As I indicated, it depends. If you had prior orders that were issued post-judgment, they generally remain in effect until those specific orders are altered or changed by the court. If they're not changed, they would remain in effect. If they are changed, then the later order applies.
Okay, so
I don't have all of your orders in front of me. I'm not going to go through them all with you right now to show what is or in effect, but that's how the court looks at it.
Okay, but like a temporary order will also stay in effect indefinitely?
A temporary order is what we call a pendente lite order, which is only in a place usually while litigation is pending. And usually that goes up until a final judgment. Your final judgment was rendered here back in 2019. So when it comes to post-judgment, it's a little bit different because it's no longer in the pendente lite world. And like I said, ordinarily, those post-judgment orders will stay in effect unless they're vacated or superseded by subsequent orders. Now, I'd like to get back to your case. What would you like to present about why you think there needs to be a restraining order issued on behalf of Angelina?
So as I was saying, that under Connecticut state law, coercive control is considered domestic violence and abuse. Coercion is also a crime under Connecticut law and can be a misdemeanor or a felony. Mr. Lodice has completely cut off all access between Angelina, myself, my 9-year-old child, the rest of our family, and any and all support system. Angelina is being mentally, emotionally, physically abused. She is also being abandoned in that she's spending all of her time with individuals who have no legal custody, no legal visitation or access to her, and no legal rights to her, whatever, particularly individuals such as Karen Bowers and Roy Bowers. Angelina is, my parental rights to Angelina have never been terminated, and I've never been substantiated for any abuse or neglect against any of my children. When Matthew was arrested on the 8th of October, he actually instructed Karen Bowers to lie to the police, lie to DCF, and lie to St. Mary's Hospital. And
Were you present when he did that?
No, I got this information from the Waterbury Police Department.
So you did not observe these things directly?
No, because there's a protective order stating that I'm not allowed to go near his house.
Okay. So that's hearsay.
Well, it's what I was told, and I'm in the process of trying to obtain records. However, Karen Bowers illegally stated that she was the legal guardian of the child and said that I'm not the legal guardian. So now I'm not able to access records because they won't give them.
She said she illegally.
St. Mary's Hospital. St. Mary's Hospital told me.
Okay, so that's something you heard from someone else.
Well, they stated that in the record, that there's information in the record that is saying that I'm not the child's legal guardian. So I am the child's legal guardian.
Well, you do not have legal custody of the child now, according to Judge Grossman's orders issued on May 31st
There's a difference between
of this year.
There's a difference
The
between
father has sole legal and physical custody.
Right, and by state
legal
law,
custody.
by state law, legal custody means that they can make major religious, educational, and medical decisions of the child. Physical custody means that they live with the child. There's a huge difference between custody and legal guardianship and parental rights. In order for parental rights to be terminated, a parent must be proven unfit. They need to be able to do that in a termination proceeding. I have never been proven unfit. My rights have never been terminated, regardless of if he has legal and physical custody of the child. That does not stop me from being her legal guardian, nor does it eliminate my parental rights.
It does empower him to make all decisions, major decisions regarding the child, and make all decisions regarding her physical custody and visitation.
And that does
So
not
my
give
question to you is
Karen
you're
Bowers
alleging-
legal guardianship.
You're alleging coercive control. This is not about Karen Bowers. You have not applied for anything against her. This is about Mr. Lodice. You're alleging that he's coercively controlled his child, but he has the right to do that under the law. So how can it be coercive control when a parent is exercising their legal rights to make decisions on behalf of their minor child?
So are you stating that he has the right to tell me that I can never see or speak to my child again and isolate her from me for 2 consecutive months with no access? Is he?
I'm asking you a question. I'd like an answer to my question.
I'm sorry, can you please repeat your question?
My question is, you're alleging coercive control, but Mr. Lodice has the right to make decisions on behalf of the minor child as any parent would over their child, which includes controlling who they see and on what circumstances, and he's expressly given that right under Judge Grossman's orders on May 31st. So my question to you is how that can establish coercive control under the domestic violence statutes.
Yes, on June 15th of 2023, we appeared in front of Judge Grossman. I told Judge Grossman that Mr. Lodice was isolating the child from me, and she asked him and she actually stated a verbal order on the record, and I have the transcript, which I can enter as evidence to prove this. She stated, and I have the audio, Mr. Lodice, you need to give Miss Antar a regular schedule with Angelina. She said to him, you need to allow her to see Angelina regularly. You need to give her a schedule to see Angelina. And you need to do this so that both Miss Antar and Angelina know when they will be seeing each other. And so that both of them are able to have a expectation of when they will be seeing each other. He stated that he was going to give me a schedule. However, in the last 4 months from June until present, he has refused to do so. And I'd like to enter in evidence at this time of all of the messages in which I ask him for the last 5 straight months to let me see my child, to give me a schedule as Judge Grossman instructed him to do, and he refuses. He either reads the message and says nothing, which is time-stamped when he reads it, or he will say things such as, oh, let me know when you're available, and then I'll let him know, and he'll say, sorry, we're unavailable then. He refuses to give me his schedule. He claims that he has no job and no income, but every single time I try to contact the child, when he was letting me speak to her, I was told that she's with his mother, or she's with his stepfather, or she's with his minor children, or she's with a sexual partner. And so during these 16 to 18 hours a day when he's working, running his construction business, Whole House Remodeling Company, LLC, he typically does not he's not with Angelina. And so during that time, when she's left with other people who have no rights to her, he tells them not to let me speak to her, not to let me see her. He refuses to give me a schedule. I've asked him for months on end to give me a schedule. He refuses. On September 1st, a restraining order was issued in Milford Superior Court, and it was in effect. We had a hearing on September 8th. During said hearing, Judge Margarita Moore, she said to Mr. Lodice on the record, and I have the transcript of that, which I can enter as evidence as well, which stated to him, why aren't you letting her see the child? And she said to him, why aren't you letting her? And Mr. Lodice just tried to make up a lie, again, perjured himself, and stated that he allegedly was telling me that I could have a schedule, and none of that is true. He never provided me with a schedule. He then started to say in the last month, oh, you can have her Mondays, Tuesdays, or Wednesdays, let me know, during the day. Now, he knows that I attend the University of Connecticut School of Law. He knows that I have classes Mondays and Tuesdays. He understands that I am unavailable during that time, and I've repeatedly told him that. So in order to abuse me further, he says to me, oh, the only time I can offer you is one, if you come to my house. He tells me I can come to his house to see her without a supervisor when there's a full residential stay away in the protective order saying it's a felony if I go near his house. He says, sorry, you can either come to my house or nothing. Then he says, sorry, the only time I can have a supervisor is if you come Mondays, Tuesdays, or Wednesdays during the day. But he doesn't give me any details about how I will be able to do that because he knows I can't go to his house. He doesn't give me a time. And if I say, okay, I'd like to see her, in the afternoon, I also have, again, my 9-year-old child who I have sole legal and sole physical custody of. She's being isolated from Angelina as well. Angelina is the applicant here. She has a right to have a sibling relationship with Juliana. She has a right to have a mother-child relationship with myself. She has a right to attend church, practice her religion. She's baptized in our religion. And so, again, she wants to go to church. She's enrolled in this religious education class. He refuses to let her go to church at all. He refuses her to have any contact with us whatsoever. And then he just says that, oh, it's his right to abuse. And Connecticut states that a coercive control is defined as A, isolating the family or household member from friends, relatives, or other sources of support. He has also done so by refusing to take her to any doctors. He removed her from school, removed her from her pediatrician, removed her from everything. He's then told my child that he's going to start sending her to another therapist, which under Connecticut law, I have the right to all medical and educational records. Non-custodial parent has the right to that. He has then said that he is not going to tell me who this new therapist that he's allegedly sending my child to is. I've asked repeatedly for the therapist's name. The child has stated that her name is Amanda.
Objection, relevance to this case?
Overruled.
She stated to me, Daddy said, and this is recorded, Daddy said that this therapist is only for me and Daddy. She said that the therapist's name is allegedly Amanda, and I've been given no other information. I've repeatedly asked him in the Our Family Wizard app, please provide me with the name of the psychiatrist who you are bringing our daughter to so I can obtain records and reach out to this provider. I have the legal right, regardless of if he has sole custody or not, to access these records under state law. He refuses. He ignores me. He says, you will never know where she goes to school. You will never know where she goes to the doctor. And he goes and he contacts these providers and he tells them that I have no legal rights to her. He tells them all my parental rights were terminated and instructs them not to give me information when, again, my rights were not terminated. There's a huge difference between custody and parental rights.
Objection, hearsay.
And so, as I'm saying, he's also depriving her of basic necessities, such as medical attention. My child screamed in pain during this phone call, which was a FaceTime. My 9-year-old child witnessed this as well. My 9-year-old daughter and I both were on the call, where my daughter was screaming in pain, hurling over in pain. Apparently, there was now...
Are those things that you reported to the police and to DCF on the date they occurred?
Yes, and just for context, as I said, Mr. Lodice has not allowed me to see Angelina since August. We're about to go into November. And so,
Were the police, as far as you're aware, ultimately able to have contact with Angelina on that day?
Yes, from what I was aware, the officers went there. They asked Mr. Lodice to let them make contact with Angelina. He refused.
And as far as you're aware, was she taken to a medical facility?
From what I was told, she was allegedly taken to St. Mary's Hospital, and I was told that now there's a DCF investigation and a police investigation, which are both active. I was contacted by the suspect...
Has DCF removed Angelina from Mr. Lodice's care?
I have no idea. I don't believe so, because I was told that they left her with the grandmother. And again, I would just like to say, too, regarding this, I was told that there is now an active investigation with the Waterbury Police, as well as a DCF investigation. I was also contacted by the Suspected Child Abuse Network Clinic, also known as SCAN, which is part of Hartford Connecticut Children's Hospital. Angelina was seen by them on June 19th of this year. Apparently, from speaking to Angelina, also has counsel, an attorney for the minor child named Joshua Pascal. There is a pending proceeding in Superior Court for Juvenile Matters in Waterbury on Kendrick Avenue, which this counsel is concerning Angelina, and this is based on a petition for termination of parental rights, and he is the appointed counsel, so he has been in contact with me.
Who filed the petition for termination of parental rights?
I filed it in probate court in July, and it was then transferred to the Superior Court in Juvenile Court in Waterbury, and we have a hearing for that on Wednesday. And I just wanted.
This is the case that you filed, not something that was brought by DCF.
Correct. I filed it in probate, and then it was transferred to Superior Court. And now there's no GAL, but this AMC, Attorney Pascal, has been in contact with me. He stated that he did do a visit with Angelina and Matthew last week. He stated on Wednesday, and I've been in communication with him. He says that he plans to bring up several of these concerns on the hearing which we have this week, which will be our first time having a proceeding of that. But I just like
Mr. Lodice, is that correct that there's a juvenile proceeding pending?
Yes, Your Honor. And it was initiated by Ms. Antar herself.
And is that to terminate your parental rights?
Yes.
And what court is that pending in?
Waterbury.
Okay.
And if I may just, about my point of bringing up SCAN, is that I was contacted by them on Wednesday, October 18th at approximately 9:30 a.m. They stated that due to this ongoing open investigation now, which was initiated by his arrest on October 8th and her subsequent visit at St. Mary's Hospital, they stated...
I thought you said they contacted you in June.
No, in June she was seen because she was seen at the emergency room on May 20th.
And they contacted you after that? Who contacted you?
So Angelina was seen by St. Mary's Hospital, by Connecticut Hartford Children's Hospital on May 23rd of 2023, where she was seen and got a sexual assault DNA sample taken, and she was evaluated for potentially sexual abuse or assault. And the pediatrician...
This was in June?
No. This was on May...
Or this is in October?
No, this was on May 23rd, 2023. And so I was advised...
Okay, and all of that, I believe, was put before the court.
No.
Before Judge about time Judge Grossman issued her orders in this matter on May 31st, because there is a reference in her decision to a recent report.
Well, so on May 23rd was when she was seen. On May 25th, we went to court. I was not sworn in. I did not give any testimony because I wasn't sworn in. I was not permitted to.
In any event, a decision has been issued, and it has not been reconsidered or vacated or reversed. So that decision is still in effect.
And if I may continue with what I was saying before to answer your question about June and that... She was initially scheduled, again, after her visit to the hospital in May. I was contacted by SCAN on May 26th. They scheduled an appointment for her to go be seen on June 19th, which she went to that appointment. And then they called DCF. Dr. Livingston from SCAN made a report with DCF due to Matthew medically neglecting Angelina, refusing to allow her to get any therapy or anything like that, and isolating her in medical neglect. DCF then did an investigation. It was social worker's name was Robert McConnell who conducted that investigation, and that took place in...
And as far as you're aware, I'll ask again, DCF has not removed Angelina from Matthew's care.
Yes, I have not heard from DCF, so I don't know for sure, but I was contacted by SCAN after this new arrest.
So let me summarize. Sounds like all of these concerns that you had up until May were brought to the attention of the court. Also, all these concerns, including after up until October 8th, have been brought to the attention of DCF and the appropriate authorities.
That's incorrect.
And up to this point...
No, that's incorrect. If I could please...
Angelina has not been... So what has not been brought to the attention of DCF or the police?
Oh, okay. So you said that all of these things were brought to the attention of the court. They were not. As I stated, I was not sworn in or permitted to testify under oath on that proceeding. I was not allowed to show evidence or address anything. The next time I went to court...
Did you tell these things to DCF and the police?
No, I didn't. I spoke to the hospital, and then my child was seen again after the last time that we went to court.
They're mandated reporters, so you've communicated these concerns to healthcare providers, to DCF, and the police.
No, you're
Is there
saying
anything
these
else you haven't
concerns.
told them?
You're saying these concerns and grouping things in as if everything that's
I am.
happened. Okay, so as I said, you were asking questions earlier about June, and then you asked the questions about now. We're here today because I filed this on behalf of my child based on the events that happened since October 8th until today. So this is 2 weeks and 1 day. In the last...
You were bringing up June, and you started bringing up things that were before that. So I would like to focus on October 8th until today. So tell me what events you're talking. I don't want descriptions of everything. Just list the events you're relying on, or the facts you're relying on in connection with your application.
Yes, and I'm asking if I may please just be able to speak without being interrupted, because I do have ADHD, and I'd like to be able to articulate what I'm trying to say here.
I understand that, ma'am, but at the same time, I have an obligation to run these proceedings in a fair and efficient manner, and I only am going to allow in evidence that's relevant and non-cumulative to the issues that are raised. You've raised certain things in connection with your application here for restraining order, and so I'm going to be confining what we're talking about to those matters that I deem relevant. Now, you just said that you wanted to shift and talk about October 8th to the present, and I would like to do that as well. So I am going to interrupt you, and I'm going to ask you to answer my question, which is, can you tell me what events, I don't want a whole description of them, I just want a listing of the events or facts that you're relying on that make you believe a restraining order is necessary from things that have happened from October 8th to the present.
Okay, yes. Like I said, after he was arrested and charged with felony risk of injury and interfering with an officer, resisting arrest, I was contacted by SCAN on the 18th of October, who stated that...
And what did they...
Yep, as I'm saying, SCAN contacted me. They stated that they needed that due to this ongoing police and DCF investigation, which are both currently active at this time, and that was confirmed by Attorney Pascal, that due to the fact that that they needed to make an appointment for Angelina to be seen in the Suspected Child Abuse Network clinic to be evaluated regarding the sexual assault allegations.
And did you tell them that she was in the care of Mr. Lodice?
They already knew this because I told them this last time. I told them this back in...
Okay.
I told them this back...
So why is that phone call relevant to the application?
Well, it's relevant because they asked me, they said they needed to schedule an appointment, and so I went ahead and said, okay, I made this appointment, which is supposed to be tomorrow at 1 o'clock. I informed Attorney Pascal about this. I asked if he could relay the message to Mr. Lodice, because Mr. Lodice has since threatened me in the app and said that if I have any contact with him, his mother, or Angelina, that he'll have me arrested for felony violation of protective order. And protective order says I can contact him in the app about Angelina, and it says that I can also call him in order to initiate contact with Angelina.
So what else besides this phone call are you relying on?
Well, for one...
With this application?
For one, I like I said, I do have several questions I'd like to ask Mr. Lodice, including if he plans to allow our child...
Before we get to that, I want to make sure I understand what your allegations are.
Mm-hmm.
So you've mentioned this scam phone call and an appointment that's set up. You mentioned the underlying arrest. You mentioned a phone call that happened. Is there anything else that you want me to be aware of?
Right. I do like you to be aware that according to Connecticut domestic violence laws, coercive control is defined as A, isolating the family or household member from friends, relatives, or other sources of support. Now, in order to enforce that, Angelina has been completely isolated from her family, including myself, my 9-year-old child, her other relatives that are related to us, as well as also eliminating her from sources of support. For example, refusing to take her to places such as SCAN, refusing to bring her to follow-up appointments from being seen in the emergency room, refusing to let her go to therapy, refusing to tell me where he's putting her in school, refusing to tell me where he's putting her in therapy, completely isolating her from me altogether. B, under the law, states depriving the family or household member of basic necessities. Basic necessities includes medical attention and being able to access a doctor, therapist, and things like that, which he has been neglecting. And C, controlling, regulating, monitoring the family's members' movements, communications, access to services. he is not going to bring her to scan, just like he told me he's not going to bring her to anything to do with this because he doesn't want to give her an opportunity to be evaluated or seen, even though this is being told by DCF and the police that this is what they're trying to do. He's also isolating her from services by refusing to let her go in the school she's in, the church that she's part of. Angelina has the right to have a relationship with me and her sister. Judge Grossman never told me or Mr. Lodice that I was to have a no contact order with Angelina. She never said that I was never to see Angelina again. She actually, in fact, told him that he needs to give me a schedule to see Angelina. He's refused to do that. And despite my many, many, many efforts, nonstop efforts to request and basically beg him to let me see my daughter, he has refused to do that. I have no way to see my daughter. I have no way to talk to my daughter. He blocked me on all his phones. He told his mother to block me. He said if I contact him again, he will have me arrested. Screamed at me on the phone and said, don't call again or I'll have you arrested. Told me in the app, if you message me again, I will have you arrested. I will have you kicked out of school. I'm going to make sure you get kicked out of school. He's been telling me for 2 years now that he's going to get me kicked out of school and that he's going to have me in jail. He's going to have me imprisoned. He continues to threaten me and use coercive control because I have the legal right, pursuant to the order that Judge Grossman put in, to call my daughter. It says I can have FaceTimes with her. It says that I can see her. It doesn't say no contact. And it doesn't say he has the right to terminate all access, visitation, and contact. And so he has no reason other than to coercively control and psychologically and emotionally abuse Angelina and myself. He has no reason to cut off contact. And he actually stated that on the 9th of October, the day after he was arrested, he stated that because he was arrested, that he's not going to let me see or speak to Angelina anymore. I've had no contact with her in 15 consecutive days, no visitation with her in 2 consecutive months, and in 5 consecutive months, only had 2 total days of visitation. That is isolating Angelina from me and the rest of our family, including her 9-year-old sister, who has no reason to not have a sibling relationship with her. There's no reason whatsoever. I've even told him we can have a professional supervisor that says that they can do therapeutic supervision, visitation, and I offered to pay for it. I said that I will do anything it takes to be able to see my child. And again, I'm having 0 access to Angelina. No contact, no access. This is isolating her from her family, which is me, my daughter, her grandmother, her cousins, her aunts, uncles, and friends and other extended family. Also, she's not able to see any of her friends from church. She's not able to go to Sunday school. She's not able to attend any events at all. My 9-year-old had her birthday on September 23rd. Mr. Lodice was at a wedding out of state. He said that he had plans and Angelina couldn't come. But when I spoke to Angelina, she actually was sitting at his mother's house alone with the mother, saying that she sat there all day long and daddy wasn't there. So rather than him allow her to attend her 9-year-old sister's birthday party, who she had been isolated from for 2 months, he refused. She was not allowed to come to the party. My birthday was on September 7th. Mr. Lodice refused to allow Angelina to FaceTime me on my birthday, refused to allow her to see me on my birthday. And
I'm going to interrupt you briefly, ma'am. I'm going to interrupt you.
Yes.
I've heard quite a bit from you on your allegations of coercive control. Are there any other grounds that you're seeking a restraining order on?
Yes, stalking, everything that's on the statute he's doing. And I'd like to ask him some questions, please.
What questions do you have for Mr. Lodice?
I'd like to ask them to him directly, please.
Well, why don't you tell me the question, and if I believe it's a proper question, I'll have him answer it.
Well, I was told that I have the right to ask him questions and put him on a stand, and I'd like to do that. I'd like to ask him the questions without...
You have the right to ask him proper questions, and I'll hear the question first, and if I deem it a proper question, I will ask him to answer it. So what is your first question?
So I don't understand. Like in prior proceedings, I was able to speak to him directly. Why am I being told that I can only ask questions if you approve of the question first?
Would you like to ask a question or not, ma'am?
Yes, I would.
I'm not depriving you of the opportunity. I'm just going to hear your questions first. So if you have a question, you can ask it now.
Okay, I'd like to know how and when I'll be able to see my child again.
Right. I don't believe that's relevant to the restraining order application here, and ultimately what the court has to decide. You have a different question.
How is that not relevant if this is based on the isolating her from me and the court has the power to make orders regarding that? How is that not relevant?
Because you're asking about future events. You haven't asked about past events. And
Okay.
I'm not, quite frankly, I'm not interested in what he intends to do in the future.
Okay, so
I'm looking at whether a restraining order is proper under the statute. What's your next question?
Okay, why has he not allowed any of us to see Angelina in 2 consecutive months?
Mr. Lodice, do you have an answer to that question?
I do, Your Honor. It's kind of a loaded question because I have tried
Just
very hard.
give me as direct an answer as you can.
I have tried very hard to facilitate visits with Miss Antar.
Objection, no you have not.
Overruled. You don't get to disagree with his answer, ma'am. You get to ask your question. He gets to provide an answer. It's the way this process works.
Will I
Go
get to
ahead, sir.
cross-examine?
That's what this is. Well, if he testifies, you can cross-examine him.
Are his
But
answers considered testimony?
You have opted to ask him questions. I'm going to hear an answer to the question. Go ahead, Mr. Lodice.
I've been trying very hard to facilitate visits with Miss Antar. She's on a third-party supervised visits only. The people I would typically try to use for supervised visits, she has since, including like my sister, my brother-in-law, people that, that can be with Angelina and her simultaneously. She has since filed all different kind of restraining orders against them, filed with them through Superior Court. So a lot of them don't really feel comfortable doing that right now. I have tried using Miss Antar supervisors in the past, and then what would happen was, which was brought up in other hearings, Miss Antar would instruct them to. Okay, let me not say that's hearsay.
Objection.
Basically, they would show up 2 hours. They would show up 2 hours late, dropping Angelina off. There was one time where there was a supervisor with Miss Antar, and when she came to the house, my mother said, "Where's Angelina's shoes?" Because she showed up without shoes. Miss Antar proceeded to bring her back into the car, and then kept her.
Objection, hearsay.
My testimony. I'm not saying anyone said it.
Objection, hearsay. None of this happened and he was not there.
Okay, so
which was it? Didn't happen or it's not there? Continue with your answer.
So Miss Antar brought her back to the car and then ended up leaving with her. So then I came back home. I followed up with Miss Antar, and she never brought my child back to me. I called the police department. The police department
When
didn't
did this
come
take
out till
place, sir?
this. I don't know the exact day. I would say beginning of July.
Okay. All right. Continue with your answer.
And
we'll have the next question.
The police finally came out the next morning. They contacted Miss Antar, who was refusing to bring Angelina back.
Objection,
And
hearsay.
then after 2 hours of conversation, Miss Antar did finally return my daughter back to me, but this is now the next morning after she was only supposed to be on a 2-hour supervised visit. So I since said, with all the problems I had with her supervisors, I said from now on, I'm going to use my supervisor as I'm supposed to be the one designating them just to avoid situations like this. So I said my mother would be happy to supervise. She has availability anytime, because I asked Miss Antar, what's her availability? She says, anytime, any day. And I have this in writing, and I can be happy to provide this with the court. And then
I think that's an adequate answer, sir. Miss Antar, do you have another question for him?
Yes, at this time I would like to enter in the evidence of the Our Family Wizard messages regarding the incident in question, which will prove that Mr. Lodice just completely lied under oath. I have every message here regarding this incident.
Do you have any more questions for him, ma'am?
I do, and I'd like to cross-examine based on the testimony he just gave.
What's your next question?
I'd like to cross-examine based on the answer he just gave.
And what's your next question?
Am I able to cross-examine and ask him this directly?
What is the question?
I'm asking if I can cross-examine him.
And I'm telling you, ask the question.
Okay. At what point did you say that this was a 2-hour visit?
Can I answer that, Your Honor?
You may.
I would like to look back. I'm going to have to look back at my records to say how long the specific visit was supposed to be, but it was definitely. I do not recall.
Okay.
But there were specific time parameters.
Next
Okay,
question.
may I refresh your memory with the Our Family Wizard messages, which I would like to now at this point officially enter in as Exhibit 1?
No, I don't believe they're relevant. I'm not going to allow them as an exhibit.
So Mr. Lodice lied under oath and just his testimony was perjury. I have the evidence right here which can show that he lied under oath, and you're saying you will not allow this as evidence?
Do you have any more questions for Mr. Lodice?
I do.
What's your next question?
Okay, Mr. Lodice, you said that I had people come late, and this is the reason why you haven't let me see my child in 2 months.
No, that's not what I said. What I said was that because of the issues I've had with your supervisors, including being late, I decided to pick the supervisor from now on myself and not allow you to pick the supervisor.
So when you say late,
Next question.
okay, my question is, you're claiming and alleging that I bring her back late. Do you provide actual times of when the visit will be? For example, on the 19th of June, do you recall that on that day, we had made prior arrangements of the 17th of June that you were to allow Angelina to spend the entire day with me? Isn't it true that you said that she could spend the entire day with me and not a 2-hour visit as you're lying under oath and claiming?
Not that I recall.
Okay, well,
Do you have any questions other than about this particular visit and issue that the two of you are talking about? I don't find this particularly relevant to the motion, and so I'd like to move on to another topic.
Okay.
You have another topic that you'd like to ask questions about?
Why haven't you allowed me to see Angelina in the 2 consecutive months, and why have you never allowed me to have a single... You've stated also, and you alleged to Judge Griffin, that you allegedly have had your brother, brother-in-law, sister, and mother as supervisors. However, you've never once stated that any of them can be supervisors. And in fact, you told your brother, Scott Lodice, to ask me for naked pictures if he was going to supervise. And he actually asked me, and I have the text messages, for naked photos as the only way that he could...
What's your question, ma'am? It sounds like you're giving an argument. What's your question?
My question is, why have you completely isolated Angelina from me and the rest of our family for the last 2 months straight, despite me asking every single day for you to provide me with a schedule like Judge Grossman instructed you to do on the 15th of June?
Do you have an answer for that question, Mr. Lodice?
I do. Theo, I am not isolating you from her. I have said multiple times in the app that I can do any Monday, Tuesday, or Wednesday day. All I've ever asked is that you just let me know the day before so I could coordinate my mother. And my mother, even though you've been doing everything like this to us, is still willing to meet you at a public place for you to see your daughter for a couple hours. And every time I ask you what day, what time of those days that you want to do it, you always deflect and say either bring it to me now or you just don't give me an answer. You've never once said, okay, fine, I can do tomorrow between 12 and 2 and then allowed for that visit to be facilitated. Never once.
Ms. Antar, do you have any questions on a topic other than visitation?
Yes, you're alleging that I never once responded. What about all of the messages where I respond every time and then you read the message and it's timestamped in Our Family Wizard that you read the message and you say nothing? You tell me that I don't respond. You say a vague statement like any Monday, Tuesday, or Wednesday.
This is getting into argument. This is not a question.
Okay,
you
my
have
question,
a question on
yes,
a topic
my
other than visitation.
my question is, why when I respond, do you read the message and say nothing?
Your Honor, I'd be happy to answer that.
Go ahead.
A lot of times when you're responding and I'm saying nothing, it's because you're asking the same question over and over again that I've already responded to. I'm not going to keep repeating the same thing. My statement back to you has been, for the last couple months, has been any Monday, Tuesday, Wednesday day, just let me know a day prior and I will facilitate that visit. That's always been my response. And then you'll ask the question over again. And I'm not going to keep responding with the same answer to the same question when I've already responded to this.
So in the past...
Ms. Antar, do you have any questions
Yes, I do.
on a topic other than visitation or your access to the minor
I would
child?
like to cross-examine based on his answer that he just stated.
No, I would like for you to answer my question, which is, do you have any other questions for Mr. Lodice on a topic other than visitation or your access with the minor child?
Yes, I do. And this is based on the topic of domestic violence, coercive control, and abuse. I'd like to have my legal right to ask him a question. Mr. Lodice, why is it that despite me asking for the last 10 consecutive weeks in a row, every single week, well over 24 hours in advance of how and when...
asked and answered.
No, it was not asked and answered.
We're going on to a new topic. Do you have questions on a new topic?
He just lied under oath. I have the right to cross-examine. I'd like him to answer this.
So I will take that as a no. So no more questions from Mr. Lodice on that.
I have questions for him, and I'd like to cross-examine him.
I have listened. I gave you several chances to answer my question, ask him a new one. You opted not to. You can disagree with my ruling.
I did not opt not to.
But I'm moving on. You've had the opportunity. I've listened to you for quite some time. And it seems to me that the thrust of your concerns are relating to your access to the minor child and your allegation that rises to the level of coercive control. Even if what you're saying is true about the denial of access, I do not find that it rises to the level of coercive control. The Constitution empowers legal guardians and people with legal custody of minor children to make decisions on their behalf.
And I'm her legal guardian.
Including their access to others and their visitation with others. Mr. Lodice has been given sole legal custody and physical custody of the minor child by this court. In order to constitute coercive control, someone has to engage in a pattern of behavior that in purpose or effect unreasonably interferes with the person's free will and personal liberty. And I don't believe that a parent making reasonable decisions about who their child sees and visits and the circumstances, especially given the record.
So you think that him telling Angelina she can never see me or speak to me again is reasonable? You think her having no access to me in 2 months is reasonable? You think that's reasonable? I'm not a person. I'm her legal guardian and mother. She has the right to see me. She wants to see me. She has the right to see her sister. She wants to. He has a pattern of refusing, and I'm trying to prove to you with exhibits. For the record, you're not allowing me to show the exhibits where I ask every time, well over 24 hours in advance, when I can see her, how I can see her, and he ignores me. She has the right to see me. I'm her mother. It is not reasonable for her to go 2 months without seeing me, nor is it reasonable for her to go 15 days without contacting me. Judge Grossman said he needs to give me a schedule and said that he needs to let me have contact, and I have no way to do that, and you're saying that that's reasonable.
Ma'am, can I finish what I'm saying?
No, because you're not allowing me to show evidence. You're not allowing me to cross-examine him. You're not allowing me to testify without being interrupted.
I will be muting you. So the court does not find that anything that's alleged, that if it has taken place, rises to the level of coercive control as contemplated by the statute. I have heard no other allegations of any other basis for issuing a restraining order. There was some mention of complaints by the minor child of stomach pain and pain to other parts of her body that precipitated Miss Antar calling the police. She acknowledged that those concerns were made known to the police and to DCF and even to medical authorities. The child has not been removed from Mr. Lodice's care given the history that's documented in the custody case. The court sees no reason to issue a restraining order in this case based on the allegations that have been brought, and the request is denied. Looks like Miss Antar has already signed off.